May it please the court. So the next issue, entirely self-contained, is whether or not the judge was correct to have found obiter that if there had been a triable issue, serious issue to be tried, that there was a gateway available. It was common ground in the court below that everything hung on whether or not the gateway in relation to an injunction restraining conduct in this jurisdiction was available. Just so that you've got a note, the relevant parts of the judgment, we don't need to go through it, but the relevant parts of the judgment are paragraphs 120 to 129, and this is, just for your note, this is respondent's ground 3, and it's covered in our skeleton at paragraphs 61 to 67. So if we just start by looking at the relief that was sought, so in the core bundle at tab 14,
yes.
And it may be easy just to look at page 148. We were looking at page 190 earlier. The only reason I just suggest we look at 148 is it just helps to navigate the amendment and the re-amendment, just to see what relates to what. So just to pick up one point, the green text was introduced, I think, just a few days before the hearing before the judge below. And it introduced...
anything in green.
Yes, I've got nothing in green.
Oh.
It assumes that we've got anything in green, but we can probably...
Okay, well that's obviously not very helpful then.
Probably find it in green on the...
Yeah.
And I also happen to have the core bundle open electronically.
Is that coloured?
That's, let us see.
148.
Yes, there we are. There's
Splendid.
some nice green.
Excellent. So you will see that in paragraph 4, what had been introduced by re-amendment was an allegation that Koza Altin, the company, was seeking to enforce indirectly Turkish penal law. That came in the last 2 lines of paragraph 4. And it was on the back of that, when you go down to paragraph 5, subparagraph 4, that an injunction was sought against Koza Altin, the company. Now that,
Hang on a moment.
we got that. So in para 4 itself, the last 2 lines are, I hope, are in green. Further, an action by the SDI or Koza Altin to replace the board or otherwise to take control of Koza Ltd would involve the indirect enforcement of a Turkish penal law. That was the basis upon which a claim was then made in paragraph 5, subparagraph 4, for an injunction against Koza Altin as opposed to the injunction against the directors personally, which previously had been all that was sought. So with just following the green, you'll see that the injunction was sought to restrain Koza Altin from taking further action on the 303 or 305 notice and or further notices under 303 or 305. Now, the one thing that the judge decided below and is not before you now is that he said that there was no tribal issue about whether or not the service of these Companies Act notices involves indirect enforcement of Turkish penal law. That is dealt with in his judgment in paragraphs 104 to 113, and there is no appeal against that. So essentially what that means is that for the purposes of considering the matter now, anything in green can be ignored because that claim has been rejected. So the injunction that is sought is an injunction to restrain.
Is that necessarily right? Doesn't paragraph 5, subparagraph 4
standalone, whether it's dependent, whether, I mean, it may have been, doesn't refer back to the Turkish penal law, does it?
Well, it is the basis upon which the addition of Koza Altin was made as a respondent to the request for an injunction. And I think it was certainly argued in the court below on the basis that the only injunction that was live, so to speak, was an injunction sought against the individual directors. Yes, as my learned junior points out, in a sense they have to accept that because their case is that Koza Altin is not before the court.
Yes.
So the injunction that is sought is to restrain the individual defendants from taking further action upon the Section 303, 305 notices, or from holding themselves out as having any authority to act for Koza Altin as a shareholder of Koza Ltd, and from otherwise causing Koza Altin to do anything or permit the doing of anything as a shareholder of Koza Ltd in this jurisdiction. Now, clearly, on the face of the page, the words that are used purport to constitute an injunction to restrain something from being done in this jurisdiction. The wording of the practice direction would be answered in the affirmative if one asks a claim made for an injunction ordering the defendant to do or refrain from doing an act within the jurisdiction. That's paragraph 3.12 of the practice direction. The question, though, that falls to be determined is whether a claimant can bring themselves within the gateway by, in a sense, characterising what they are seeking as an injunction to restrain conduct in this jurisdiction, when in fact no such conduct can, in the relevant context, be caught. And the reason we say that, very shortly, is simply that the directors, as you know, are in Turkey. What they do by way of board meetings and decision-making takes place in Turkey. If, on the basis of that, whether or not they have the authority to do it, if, because of that, Koza Altin does something in this jurisdiction, that is a consequence of what the directors are doing in Turkey. It is not conduct by the individuals. One of my learned friends' answers to this line of argument is to say, well, that assumes that we, the respondents, have won the authority issue. He says the authority issue is whether the English court should recognise the authority of these directors to get Koza Altin to do anything. But that, with respect, is a false point. Excuse me. The authority issue, as we have established, does not ask the English court to rule that the individual directors do not have authority to cause Koza Altin to do anything. The authority issue is a request to the court simply to ignore, for England, the authority that does exist. If the English court accepts that argument and it chooses to say Koza Altin is not before the court, Koza Altin has not served the Section 303 notice, that does not turn the Section 303 or the 305 notice into a personal act by the individual defendants. It simply results in the English court not treating them as acts of the company. So my learned friend is not, with respect, able to say coherently that if he wins the authority argument, somehow the Companies Act notices will be deemed to have been served by individuals in their own right. That isn't the consequence of success on his part. And similarly, the other point that was run in the court below is that this is somehow analogous to the case of Tozier and Hawkins, which was, it may be just worth looking at that briefly. So Tozier and Hawkins is in the Authorities Bundle 1 at tab 6. And this was a case where an injunction was sought against somebody in Ireland who was publishing defamatory material, libelous, defamatory or obscene postcards by post. So being sent from Ireland to England in the post. And the question arose as a question of interpretation of the then rules of the Supreme Court as to whether an injunction could be granted. Now, what is, well, let's just look at the case and then we'll discuss the argument. So it's extremely short judgment, and we just go to the second page, page A151, and you'll see the Chief Justice. It says very nicely that Mr. Winch argued the case with great ingenuity and perfect fairness, at which point Mr. Winch obviously knew he was going to lose. His contention is that his contention is that Order 11 Rule 1F does not authorise the court to issue an injunction to a person resident out of this country to restrain the doing of something within it. If that were the true construction of the rule, it would be wholly inoperative. It provides that service out of the jurisdiction of a writ of summons may be allowed by the court or a judge wherever any injunction is sought as to anything to be done within the jurisdiction or any nuisance within the jurisdiction is sought to be prevented or removed. I am of opinion that that rule gives us abundant jurisdiction in this case. Part of the order, at all events, could be enforced. No answer was given to the second point. So, the point, in fact, this case actually assumes the very points that we are arguing. We are arguing that the injunction that is being ostensibly sought against the defendants does not seek to restrain the doing by them of anything in this jurisdiction. And so, with respect to the judge below, he was wrong to draw comfort from that. He treated it as if it were authority for the proposition that something done outside the country, which has consequences inside the country, is conduct in the country. And that isn't what this case decides. This case assumes that what was being done was the doing of something within it. I mean, assume it. I mean, one would think quite rightly, because what was happening was publication in England by post. So, yes, the post starts in Ireland, but the publication takes place in England. So there is conduct in England. But that is conduct by the person who is sought to be restrained by the individual.
The case proceeds on the assumption that the libel was published in England.
Yes, exactly, because
That's what Lord Coleridge says during the course of argument. And then
yes, exactly.
Mr. Winch then shifts his ground and concedes that point, but says that there was no jurisdiction because the court couldn't enforce the injunction.
Yes.
So he moves to a different point.
Absolutely, absolutely. So that this case doesn't assist the court, sorry, Tozier and Hawkins doesn't assist you.
Doesn't assist much, that's for sure.
And it certainly shouldn't have encouraged the judge to reach the view that something which is done by directors outside a company, outside this jurisdiction, which causes, whether with a lawful authority or not, which factually causes the company to do something here, involves conduct by the directors in the jurisdiction. It doesn't. So the argument we put in front of you, it's very short, and in one sense it's a slightly refined argument. We do acknowledge, as I say, that the words on the page, so to speak, the actual words of the injunction do fall within Gateway 2. but what is in fact being sought falls outside it because there can be no relevant conduct by these individuals which would be caught. And the point really is as short as that. Abuse of process, last issue. You will obviously appreciate the basic outline of the argument here. We say that it was an abuse of the process of the court when taken in the overall context of the proceedings as a whole, for the claimants to have put all their eggs into the exclusive jurisdiction basket of Article 24.2, to have refused to move the application which they had issued, seeking permission to serve out in the alternative, to fight exclusive jurisdiction as they did, all the way up to the Supreme Court, lose.
When were they going to advance that application?
At the very
between
outset.
their success in the Chancery Division and their failure in the Supreme Court?
What should have happened is that the court should have been invited to deal with both at the very outset in the alternative. And the application notice as originally issued sought both. You don't know when you start making...
I wasn't a Chancery Division judge, as you know, but if you'd made that application to me in the commercial court, I would have said, no, thank you very much. Let's see what happens with the Article 24 point.
Well, my lord,
I don't have much doubt that most Chancery Division judges would have saying the same line. That's the fallacy in your argument with respect. They had the application, they didn't pursue it because it was academic. So to suggest that not pursuing an academic application is an abuse of process is slightly problematic.
well, Lord, if your lordship remains of that mind when you write the judgment, then I will have lost this point. But if I can take a little time to try and dissuade you.
As Mr. Justice Leggett Senior once said to me, Mr. Crowe, you may seek to persuade me at that point, Mr. Fleur. That's presumably what they've employed you for. I wouldn't dream of being quite so offensive.
I mean, in a sense, part of the answer to what your lordship just put to me is this: that the question whether or not something is or isn't an abuse depends on the conduct of the party, not on speculation as to what the court might have done if the party had behaved differently. It is entirely possible. I mean, just slightly passed over the applicable test, but we've started on this. And if the application had been made asking the court to rule, in a sense, contingently on permission to serve out, at the same time as the application was made for a ruling that permission was not required, there obviously would have been three possibilities. Either permission to serve out would have been granted in the alternative to the ruling on Article 24.2. If permission had been granted, it would not have mattered whether the court had exclusive jurisdiction. And at the very least, what would have happened is that if we had appealed on permission to serve out, then the appeal on that and any appeal against a refusal of exclusive jurisdiction could have proceeded in parallel.
So you said it was in their application
Yeah.
notice, but it wasn't pursued.
It wasn't, no, despite, and I want to take you through the facts in a moment, but I just want to just try answering what's been put to me and then loop back very slightly. Obviously, the second alternative is just the converse there, which is that permission to serve out would have been refused, and then, depending on who won or lost on exclusive jurisdiction, again, appeals on each could have progressed at the same time. Or the court could have done what your Lordship just suggested, which is to refuse to deal with the application for permission on a sort of contingent basis. Now, if that had happened, I would not be standing here. But as we would submit, the question of whether or not something is an abuse depends on what the litigant has done, not on a speculation as to what the court might have done if the litigant had acted differently. And
what it really amounts to saying on this hypothesis is that what they should have done before Mr. Justice Snowden is to say to the judge, well, actually, we've got these two applications. If you deal with the permission to serve out application, then it doesn't matter whether there's also exclusive jurisdiction. Therefore, deal with the permission application. That doesn't seem to have been suggested, but that was a tactical decision that was made at the time, or a case management decision that was made at the time.
Whichever way, and essentially the complaint is this, that by taking, so to speak, a unilateral decision only to run with exclusive jurisdiction argument, the claimants deprived the court of the opportunity of case managing appropriately. So you are now left in the position of having to speculate as to what a court might have done if it had been given the choice as to case management. And the fact is that the skeleton argument that was put in front of Mr. Justice Snowden, as he then was, did run both arguments. And the evidence that was adduced addressed both arguments, both exclusive jurisdiction and service out. I'll just I got slightly out of the sequence. Can I just look back and make sure I haven't missed anything out so I go forward? What I had wanted to do very briefly, just to remind you, if it were necessary, of the applicable test. And there's just one sort of key expression which you probably have well in mind in any event from the Johnson and Gore Wood case, which is quoted, we've got it in bundle 3 at tab 38. It's actually another Court of Appeal decision in this very case, in the Koza battle, but we've already had
a few statements of principle.
We've got a few statements of principle, and we've got not least the question which helpfully decided that the question of Henderson and Henderson abuse applies not just as between substantive causes of action, but also as in relation to interlocutory applications within a single set of proceedings. And if we could just look very briefly at page 1415, so electronic page 1415. And we get the quote in paragraph 32 of the Koza judgment. We get the quote from page 30 of Johnson and Gore Wood. And if we just pick it up between F and G, you probably had this quoted to you many times. Henderson and Henderson abuse of process as now understood, although separate and distinct from cause of action and estoppel and issue estoppel, has much in common with them. The underlying public interest is the same, that there should be finality in litigation and that a party should not be twice vexed in the same matter. This public interest is reinforced by the current emphasis on efficiency and economy in the conduct of litigation, in the interests of the parties and the public as a whole. The bringing of a claim or the raising of a defence in later proceedings may, without law, amount to abuse if the court is satisfied, the onus being on the party alleging abuse, that the claim or defence should have been raised in the early proceedings if it was to be raised at all. I would not accept that it is necessary before abuse may be found to identify any additional elements such as collateral attack on a previous decision or some dishonesty, but where those elements are present, the later proceedings will be much more obviously abusive. It is, however, wrong to hold that because a matter could have been raised in early proceedings, it should have been. so as to render the raising of it in later proceedings necessarily abusive. That is to adopt too dogmatic an approach to what should, in my opinion, be a broad, merits-based judgment, which takes account of the public and private interests involved, and also takes account of all the facts of the case, focusing attention on the crucial question whether, in all the circumstances, a party is misusing or abusing the process of the court by seeking to raise before it the issue which could have been raised before. Now, what is somewhat paradoxical about this case is that the permission to serve out was a point that was raised, but the claimants just took a unilateral decision not to ask the court to rule on it. And that has resulted in this truly astonishing situation that the proceedings were issued 6 years ago. This is our 4th journey to the Court of Appeal. We've had 1 journey to the Supreme Court. And here we are arguing about permission to serve out. 6 years after issue. If the claimants had invited the court to rule on permission to serve out in parallel with exclusive jurisdiction, we would, even if that had gone to the Supreme Court, we would have had the answer 3 years ago. These proceedings haven't progressed. It is truly astonishing after 6 years that we are still squabbling about jurisdiction. So the question, having just reminded you of the Johnson and Galwood, there are clearly 2 questions. Could the point have been raised earlier, and should the point have been raised earlier? And then thirdly, taken in the round, is what is happening an abuse? As to that very first question, could the point have been taken earlier? Plainly, yes. And indeed, Mr. Justice Trower did accept that in paragraph 143 to 147 of his judgment. It plainly was a point that could have been taken. There is no appeal against that ruling. So the only question, essentially, is whether it should have been raised earlier. And one of the introductory points to that we would wish to make is that it does not lie in these claimants' mouths to say, oh, well, we didn't want to ride 2 horses. Because they were, in fact, riding 2 horses on another aspect of jurisdiction when it suited them. And what I mean by that is this, that you will obviously be aware that their main point was the court has exclusive jurisdiction under Article 24(2). But they ran an alternative argument that the defendants had submitted to the jurisdiction by filing a counterclaim. Now, we just look very briefly at how that was dealt with. So it's in the same bundle, Authorities Bundle 3. That gets ventilated in front of Mrs. Justice Asplin, as she was. So Authorities Bundle 3, tab 34. And if we pick that up at page 1282, we'll see, having dealt with the exclusive jurisdiction issue on page 1282 at paragraph 49, her ladyship then dealt with submission to the jurisdiction. I will also go on to consider whether the defendants have submitted to the jurisdiction, because that was the argument that was being run in the alternative to exclusive jurisdiction. So it simply doesn't lie in the claimant's mouth to say, oh, well, we couldn't really ask the court, or shouldn't have asked the court to deal with alternative bases for jurisdiction, because they jolly well did so when they thought they had a winner. And they simply chose not to in relation to permission to serve out, because they knew they had some more hurdles to jump. Now, as it happened, it doesn't really matter what happens to the argument, but just so that you know the course of events, Mrs. Justice Asplin accepted the argument that there had been submission to the jurisdiction. So paragraphs 49 through to 56 deal with that. and you'll just see, just so that you can see where she lands, at the very top of page 1284, first line on the page, the very end of that line. In my judgment, therefore, objectively viewed, the counterclaim amounts to an unequivocal submission to the jurisdiction. Now, that point was appealed to this court, and in the next tab is a judgment in which your lordship appeared with Lord Justice Floyd, and you came to a different view. And that is, if we just look quickly at page 1309, you'll see that the court rejected the argument on submission to the jurisdiction at paragraphs 55 through to 61. Now, as I say, exactly how that was disposed of doesn't matter.
Yeah.
I'd simply draw to your attention to illustrate the fact that the claimants had chosen to run alternative arguments, as I say, when it suited their purposes. So, moving on through the question as to whether or not the claimants should also have run with permission to serve out, simply as an important point of chronology, it is the case, this isn't some sort of clever point we thought of after the event. We warned them fair and square right at the outset that we would take a point on abuse if they did exactly what they have now done. So if we just look in Supplemental Bundle 2, tab 43, so this is a letter from my instructing solicitor in November 2016. So this is in the run-up to the hearing I'm so sorry. Supplemental Bundle 2, tab 43. So this is a letter from my instructing solicitors in November 2016. The ex parte application in front of Mr. Justice Snowden has been heard, we are now in the run-up to the hearing in front of Mrs. Justice Aspling. I do apologise, I just missed out in the chronology. Could I just go back? I apologise. Just keep that to one side. I just wanted to take you to the skeleton argument. I mentioned this, I didn't take you to the document, but it's helpful to do so. So the skeleton in front of Mr. Justice Snowden is in Authorities Bundle 1, tab 18. So, what do I, sorry, Supplemental Bundle 1, tab 18. And if you turn to the large, heavy page numbering at the bottom, SB 269, you'll see just above halfway down the page, there's service of the proceedings. And then below that, there's an italicized heading, service abroad without permission, paragraph 40 to 42. And over the page, at the bottom of the page, just above paragraph 43, there's the italicized heading, service out with permission, which then goes on for a considerable number of pages, up to page 274 when they get on to full and frank disclosure. So I just wanted to...
This is before Mr. Justice Snowden.
That's right.
Mr. Justice Aspling, yeah.
Yeah. So that was the August, I think. Yeah, August 2016.
Yeah.
We then get the return date in December in front of Mrs. Justice Aspling. In the run-up to that, my instructing solicitors write the letter I was just about to take you to. So back into Supplemental Bundle 2, tab 43. And you'll see that Mishkon's say that there appears to be a fundamental difference between us as to how jurisdictional challenges work. As you acknowledge in your letter, your clients proceeded before Mr. Justice Snowden on alternative bases. Primarily, that permission to serve out was not necessary, and alternatively, that if permission to serve out was necessary, it should be granted on various bases. Mr. Justice Snowden determined that permission to serve out was not necessary, and so didn't proceed to determine your client's alternative contentions. It is perhaps worth noting that in your client's skeleton argument for their ex parte application, they expressly accepted that it is necessary for them to show that service out of the jurisdiction is appropriate against all of the defendants, with or without permission. And they expressly reserve the right to rely on certain gateways for permission to serve out, in the event that it is argued or decided that the heads of jurisdiction referred to above are not available. Those positions were entirely unsurprising. Our clients have now made a jurisdictional challenge. They say that not only was Mr. Justice Snowden wrong to find that, insofar as a jurisdictional challenge is applicable, Article 24.2 applied, but there was no supportable jurisdictional basis for the proceedings. In other words, the contention is that both your client's primary and alternative bases for jurisdiction were wrong. Your current position appears to be that because Mr. Justice Snowden accepted your client's primary argument, it is only the question of whether he was right to do so that can be live on our client's jurisdiction challenge. Yet, at the same time, they are not prepared to say that if our clients succeed in demonstrating that Mr. Justice Snowden was wrong to accept your client's primary argument, they will not rely on any other basis for jurisdiction, either now or in the future. We consider that such a position to be entirely unacceptable. The question of jurisdiction should be dealt with as a whole. It would, in our view, be manifestly inappropriate and indeed an abusive process for you to insist on the question of jurisdiction being addressed piecemeal, particularly when your clients should be ready to address the issue as a whole, given that they were ready to do so and did so in their original ex parte application. With respect, such an insistence smacks of game playing. Now, with that fair warning...
Was that letter before Mr. Justice Trower?
Yes, I'm sure. Yes, I'm sure it was.
Doesn't refer to it.
He may not, I can't remember. Can I check that?
You warned them.
So the first point, as I say, this is not a sort of clever after the event point, saying, look where we've got now that the Supreme Court.
But on the other hand, merely asserting along the way that if you don't do something, we'll say it's an abusive process, doesn't make it.
Of course it doesn't. Absolutely accept that. But it is
exactly the same course, was a different factual scenario, but exactly the same line was taken by the defendant's solicitors in Kennicott and Minette. And indeed, it was cross-examination in the first instance of both, I think, of the solicitors and the barristers. I can't remember now. Along the lines of, you were warned. This is what would happen. Look what's happened.
Yeah. Well, I entirely agree, my lord. The fact that this letter was written doesn't prove anything.
Was there a reply?
If there was, I don't know what it said. Well, I mean, essentially the thrust of the reply was, we are going to move inter partes our application on the basis of exclusive jurisdiction, and that's all we're going to ask the court to do. And that is what happened.
And Mrs. Justice Aspin doesn't deal with this at all.
No, she doesn't, because she wasn't asked to.
What the judge says, and I haven't looked this up, in paragraph 138 of the judgment.
Yeah.
It says, in the light of this difference in approach, Mr. Stephen Orr, then acting for Koza Altin, told Mrs. Justice Aspin that his clients understood that the permission application was not being pursued, but did not go on and say that it should be decided in the alternative in any event.
That's right. And he then goes on to say, in the circumstances, I think Mr. Akmal and Friend's predecessor is correct to submit that it was Koza Altin and the trustees who decided at the hearing not to pursue that part of their 7th October jurisdiction application, which dealt with permission to serve out. With greatest respect, that is just wrong. The question whether or not the court grants contingently permission to serve out depends on whether the claimants asked for that relief. We couldn't force the claimants to move their application on the basis of seeking permission to serve out in the alternative. And if they chose not to, and they did choose not to, there's nothing for us to answer. So it's greatest respect when one is dealing with an application for leave to serve out or for an application to declare that leave isn't required. The onus cannot possibly be on the defendant to force the plaintiff to move an application the plaintiff chooses not to move.
I mean, in one sense, you're obviously right, but you'd said in the letter that you would invite the court to proceed upon the basis that the question of jurisdiction should be dealt with as a whole. Come the hearing, doubtless very understandably, you don't go on to say that it should be decided in the alternative. Now, was the judge not entitled to take that into account as part of the broad merits-based decision he had to make? And of course, when you're trying to upset a decision by a judge on abuse, you can't just say, well, it might have been decided differently. You have to show that he took into account something immaterial or whatever, or arrived at an entirely unreasonable decision.
So in relation to what Mr. Justice Trower decided, we do submit that it is simply wrong in principle for him to proceed on the basis that, so to speak, fault lay with us, because it wasn't our application. We had written the letter that we had. We had put in front of the court, and if you want the material, I don't think you're not going to learn a great deal from it, but just so that you've got the note in the supplemental bundle supplemental bundle 2, tab 21, is extracts from our skeleton in front of Mrs. Justice Asplin, and we deal with permission to serve out at page 302 onwards.
I mean, what your solicitors had said in their letter was, unless you confirm that you'll only pursue Article 24 and you'll abandon permission to serve out, we'll invite the court to deal with all the issues of jurisdiction. And those issues of jurisdiction included your client's own jurisdictional challenge, which challenged the entirety of the basis for jurisdiction, both exclusive jurisdiction and jurisdiction which will require permission.
Absolutely.
And the only point that as I read it, Mr. Justice Trower was making is, notwithstanding you said that's what you were going to invite the court to do, you didn't invite the court to do that. So that in the context of abuse, I mean, it may be that he's perhaps saying that, I mean, all he's saying at 139 is that you decided not to pursue your own jurisdiction challenge and not to invite the court to deal with jurisdiction as a whole, which is factually correct.
Two things. The skeleton for the hearing in front of Mr. Justice Asplin says, it quotes the letter we just looked at. Actually, it does partly answer because it then quotes the response. Sorry, no, it doesn't. It quotes a subsequent letter. And then it goes on to say, conspicuously, however, they, that is the claimants, did not give the confirmation or undertaking sought by the defence in the circumstances the defendants are ready to deal with the question of jurisdiction as a whole at this hearing and would invite the court to do so as well. That's paragraph 13.5 of the skeleton in December 2016, page 296 of the bundle. Now, if a defendant facing essentially the inter partes hearing of an application to serve out says it's ready to deal with an issue, and the claimant chooses not to ask for permission to serve out, what is the defendant able to ask the court to do? It is resisting jurisdiction, but it can only resist jurisdiction on the basis that it is being claimed. And it wasn't being claimed by the claimants on the basis of permission to serve out. So there was nothing for the defendants to answer, which is why I say that the defence were in the invidious position of being unable to force the claimants to move the application on the alternative basis of permission.
I'm not at least saying you should have done these things, but you couldn't you have done what you're saying now? You could have explained that it could be really inconvenient for these matters to be dealt with separately. Please, Judge, will you look into both of them at the same time?
Well, Lord, as I say, that fairly read is exactly what our skeleton says. It quotes the letter I've just read to you, and it says we're ready to deal with it.
And
But that wasn't,
That wasn't what Mr.
sort
Old
of
said.
emphasised at the hearing.
Well, Mr. Old positively didn't go on and say that it should be decided in the alternative in any event. That's 138 of the judgment.
Yeah. And given
Well,
that,
he may not have
and
said
the
that
other
orally,
point
I
the
don't know. I
judge
mean,
is making is that given that the claimants had not been prepared to give any sort of undertaking that they wouldn't ever pursue the permission application, at that stage, your clients knew that there was always a risk that the permission application would come back. And that's,
Yeah.
in terms of assessing whether there's an abuse of process, that's an important consideration, isn't it?
well, not really, with respect. I mean, to know that there is a risk that somebody may commit an abuse doesn't diminish the abusiveness of what is then done.
That's not the point I'm putting, John.
Sorry.
You
Well, I
know
think
the
I'm...
risk that the permission application might be pursued at
Yes.
a later stage.
Yes, they did.
So, I mean, what my lady just put to you is that they could, your clients could, through Mr. Auld,
I've tried
said to
harder.
Mrs. Justice Asplin, we are concerned that you know, this permission application is hanging out there, and it may, the claimants appeared not to be prepared to abandon it, so it ought to be dealt with now. And if she then said, well, I'm not going to deal with it, Mr. Auld, then we'd be in a different position.
Well, Lord, as I say, I can't take it further than reading what the skeleton said at the time. As I say, it quotes the letter that I've read to you saying it would be an abuse, and then it says, in the circumstances, the defendants are ready to deal with the question of jurisdiction as a whole at this hearing and would invite the court to do so as well. If Mr. Auld on his feet didn't press that, I have to live with that as a matter of record. But the position we were in is that the skeleton argument canvassed the arguments in relation to permission to serve out. Evidence was adduced in relation to permission to serve out, and the skeleton on its face asked the court to deal with that. As I say, whether that request in the skeleton was pressed orally, I can't say. We don't have the transcript. I haven't seen the transcript of that. But that is where we are. Could I just, just running through those Johnson and Gorwood principles, could the application be made in the alternative? Yes. Should it have been made? We submit yes, essentially for the reasons in that letter. I'm not suggesting the letter proves it's an abuse, but it identifies the very risk that we of the adverse consequence which we now find ourselves in. The third question under Johnson and Gorwood then is in the round. Should the court come to the view that the proceedings do constitute an abuse? And so far as that is concerned, there's a collection of considerations which we would invite the court to take into account, which in our submission the court below did not take into account, or at least did not attribute to them any significance which they should have borne. The first point is simply this. There was a very significant delay between the expiry of the original authority claim and the institution of the new one. So the chronology is that the original authority claim survives Mrs. Justice Asplin, it survives in this court, and it is dismissed by the Supreme Court in July 2019. it is not until March 2021 that the new authority claim is issued. So, as part of the overall assessment of whether or not raising later an issue that could, and we would submit should have been raised earlier, a significant consideration is, well, how quickly do they pick up and run with it again? And the answer is
Not very.
not at all, no. I mean, 18 months, 20 months.
Let me just talk that round that for a moment. Suppose they hadn't picked it up at all again. Or suppose now this court said, well, we don't need to deal with any of the other issues in the case. We will dismiss the appeal on the basis that there's no gateway or that there's abuse. What actually happens? I mean, you've got your notices under the Companies Act. Assume that Mr. Ipek and Koza decide to ignore them on the basis that you have no authority to give to serve them on behalf of Koza Altin. What happens?
Sorry, is the hypothesis that there is or isn't an injunction?
Forget about the injunction.
Okay.
Assume there's no injunction.
Right.
Assume that either the present claimants didn't bring any further proceedings,
Right.
or that this court disposes of these proceedings on the basis that there's no gateway or that there's abuse. I mean, that doesn't deal with the question of what happens to the notices. So what does
No.
happen to the notices?
Well, what the Companies Act says is that notices, that Koza Altin has served a notice under Section 305, and a meeting of the members can be held, and a resolution passed to remove the existing directors.
And assume that, I mean, there would on this hypothesis have been no decision that you had authority to serve such a notice. So assume that those in this country, Mr. Ipek, Koza, ignore your notices. Don't you end up needing court proceedings sooner or later, in which case, why not have them?
Would we need court proceedings in order to extract from Mr. Ipek's unwilling hands the books and records of the company and the bank account? Yes, presumably so.
So you would then have some further years down the line be bringing proceedings.
Unless he accepted that what he had done was unlawful and capitulated. Again, we're in the world of speculation as to what might have been.
Sort of, but when you say, well, they waited a long time, if sooner or later you're going to end up there anyway, does it matter how long they waited?
Well, it does, because what the court is assessing is whether or not the conduct of these litigants is, in the overall scheme, in the overall context, abusive. And the fact that they may be obstructive in other proceedings, they might have been obstructive in other proceedings by refusing to hand over company books and records, doesn't prove that this conduct isn't abusive. It simply demonstrates that they may be obstructive they might be obstructive in another context.
And isn't that something you can take into account as part of the broad merits-based assessment that this is going to have to be litigated sooner or later anyway, unless it's disposed of on the other grounds that are raised by this appeal?
I mean, there are, in a sense, two interested parties, although I represent them both. The company is one, is the individual directors who keep getting dragged, so to speak, to this jurisdiction unwillingly. There is no earthly reason why they, personally, should be expected to bring proceedings in circumstances where, under the law of the jurisdiction where they live and of the company itself, they are the directors. There's no reason at all why they should have had to bring any proceedings.
But they would cause Koza Altin to bring proceedings, and at that stage, Mr. Ipek would say, no, you have no authority, and the substantive questions would be the same.
If that had happened, yes, that would have been the sequence of events. But as I say, the question of abuse, we would invite the court to take the approach that the question has to be determined by reference to what did happen, how the litigant in front of the court did behave, not by reference to speculating as to what might have happened either in front of Mrs. Justice Asplin or if no proceedings were taken.
And is that warranted by Johnson and Gore Wood, where Lord Bingham says there has to be a broad merits-based judgment which takes account of the public and private interests involved and also takes account of all the facts of the case?
Yeah. So the facts of the case, the question is the party accused of abuse guilty of abuse? Is that person's conduct abusive? And in our submission, it is a significant element in that Mr. Ipek, and through him Koza Ltd, waited 20 months before issuing the new proceedings, and indeed only did so, I think, after, they only amended the original proceedings after an for an unless order. So, sorry, that took slightly longer than I intended. So that was just the first point, delay in bringing the second set of proceedings. Parallel, very closely related, but parallel to that, there is the fact that Mr. Ipek was warehousing the 2016 proceedings. So these are closely related points, but the first point is that he did not issue the new authority claim for 20 months. As it happens, he also didn't get round to amending the 2016 proceedings after the Supreme Court judgment. All he had to do was to delete the authority claim from the 2016 proceedings and serve an amended claim form. He didn't do that until November 2020. So he took 14, 15 months from the Supreme Court judgment before issuing an amended claim form. And that is, in our submission, a failure to get on with proceedings is a relevant factor which we invite the court to take into account. I don't need to take you to it, but the authority we've cited is Al Ibrahim and Asturian Foundation, which is in the Authorities Bundle 2 at tab 24. So there's delay in reviving the authority claim. There's delay in moving forward the 2016 proceedings, the English company law claim. The third point is that delay is more grievous because Mr. Ipek is sitting on interim relief granted in December 2016, which gives him de facto control over Koza Ltd, a company which he has no beneficial ownership of. He's got this golden share, but it is the wholly owned subsidiary of Koza Altin.
I mean, I do see that point, but at the same time, you look through your company, he does have an interest, or his family has an interest.
His family have an interest in the parent company, I agree, a minority interest in the parent company. But the fact is, what this case is factually about is that Mr. Ipek caused £60 million to be transferred from Koza Altin to Koza Ltd, and has been using that essentially as a sort of fighting fund to run all sorts of proceedings, and we'll see in a moment that he has been doing that in breach of his fiduciary duties. He has simply parked a sum of money in Koza Ltd to use it, we would submit, for his own personal purposes. But the fact is, we do have to accept that an interim regime needs to be in place, pending trial, and since December 2020, Mr. Ipek has had de facto control over Koza Ltd. Now, if a party gets the benefit of interim relief for his protection, he comes, in our submission, under a heightened obligation to move the proceedings forward and should not be allowed, in the words of injunction lawyers, to warehouse the proceedings sitting on his interim relief, but not advancing the substantive disposal of the issues. And again, we don't need to go to it, but simply to give you a hook on which to hang that submission, that where there is interim relief, there is a heightened obligation to move the proceedings forward. We've simply included in the authorities bundle 1 at tab 6, some extracts from G on injunctions, and we would just remind, the reference is in our skeleton, but just to remind you, it's paragraph 24029 to 24032. The fourth point, which aggravates the gravity of Mr. Ipek's conduct, is that he has been guilty of at least two significant acts, which even on an interlocutory basis, the courts have found there is a high degree of likelihood that he has acted in breach of his duty as a director of Koza Ltd. The two things he has done that we can specifically point to is that he caused ICSID arbitration proceedings to be issued in the name of a company, Ipek Investments Limited, which he was trying to use as a vehicle, yet again, for ventilating his grievance against the Turkish state. And just to give you the background, obviously the arbitration proceedings are based on a bilateral treaty between the UK and Turkey. Koza Altin is the parent company. It's a Turkish company. It has nothing to do with the UK, but Mr. Ipek said, but I backed my family interests into an English company, Ipek Investments Limited, and Ipek Investments Limited is entitled to the benefit of the bilateral treaty with Turkey because it's an English investor. One of the main flaws with that, leaving aside whether there's any merit in the substance, one of the main flaws with that is that the share purchase agreement under which he claims to have backed his family interests into Ipek Investments Limited looks very much like a forgery. It has been in front of the court, scrutinised on a number of occasions, and it has been regarded with a high degree of probability as a false document which has been backdated to make it look like it was entered into some years before its actual date. It has all the hallmarks of a somewhat incompetent forger, for example, using as a head office an address that wasn't the head office of a company at the time, other matters like that. It doesn't really matter what the evidential basis is. I'll take you to just a couple of remarks soon. So that's one thing, deploying a forgery in order to run an ICSID arbitration. The second thing that Mr. Ipek has been doing is using Koza Limited's money to fund his personal claims for, it would appear, the ICSID arbitration and to fight these proceedings. It is an elementary point of company law that a company has no interest in who its shareholders are. The real substance of this dispute is clearly between Mr. Ipek personally, which is why he keeps getting ordered to pay the costs of unsuccessful applications personally. It's a dispute between Mr. Ipek personally and those he perceives to be organs of the Turkish state. Koza Limited has no interest in that, but he has been repeatedly using Koza Limited to fund the litigation. That has involved, in a different judgment of Mr. Justice Trower, to constitute what he regarded with a high degree of probability as breach of fiduciary duty by Mr. Ipek as the director of Koza Limited. Without spending an unnecessary amount of time on this, can I just very briefly take you to, first of all, the forgery point. So in Authorities, Volume 3, tab 37. And this is a judgment given by a deputy judge in relation to an application by Koza Altin for an injunction to restrain Mr. Ipek from using Koza Limited's money to fund the ICSID arbitration. And we can just quickly pick up a couple of passages. If we go to page 1384, because this was the second time in which the question whether or not the share purchase agreement on the basis of which the ICSID arbitration was founded was a forgery. It had been considered already by Richard Spearman QC, sitting as a deputy on an earlier application. So Mr. Cousins QC, sitting as he was as a deputy in this one, was reconsidering a situation where Mr. Spearman had already decided there was a high probability that the document was a forgery. If we look at page 1384, paragraph 85, he says he takes into account Mr. Lamb QC's evidence, that's evidence sworn on behalf of Mr. Ipek, as to there now being available more evidence, including witness evidence, which supports the claimant's case on the authenticity of the share purchase agreement, than was available on the ICSID funding application in front of Mr. Spearman, whether at first instance or on appeal. Making due allowance for that, in my view, there still remain reasons for very serious doubt as to the SPA's authenticity. The issues cannot be tried now any more than they could at the early stage. I do not understand Mr. Flynn to be submitting that I should depart, or indeed that I would be justified in departing from the unequivocal expressions of real and serious doubt expressed by Mr. Spearman or the Court of Appeal on the topic. And that leads to the conclusion at page 1396, paragraph 109. I'm satisfied, having weighed all relevant factors, that the balance of convenience comes down clearly in favour of the grant of an injunction as sought by in the application. As per Koza Altin's undertaking in damages, not demonstrated, blah, blah, blah. But he goes on to say, and the cross undertaking is, I consider, adequate, particularly when I reflect upon the high degree of assurance that I entertain that at trial it will appear that the injunction was rightly granted. So he's saying that there is a high degree of assurance that the injunction is justified on the basis that the whole ICSID arbitration is founded on a forged document. Notwithstanding the warnings that had been given in correspondence about using Koza Limited's money to fund this litigation, Mr. Ipek has been doing just that, and a judgment at tab 39 of this bundle had to be given, again, another one by Mr. Justice Trower, on an application for an injunction to restrain Mr. Ipek from using Koza Limited's money to fund this litigation. And again, it's just helpful to see a couple of things to give proper context to what it is in front of the court. So if we just go to page 1472, paragraph 58. On the basis of this evidence, I am satisfied that administrative expenses for the period in fact exceeded £20 million, and that the likelihood is that a material proportion of that figure, almost certainly amounting to very substantially in excess of £10 million, and quite possibly as much as £17 million, has been spent by Koza, that is Koza Limited, on legal advice and representation, including these proceedings. And he goes on, if we go to page 1483, paragraph 113, in all the circumstances, I'm satisfied that there is a serious issue to be tried, that in procuring Koza Limited to pay all the legal costs of these proceedings and the new authority claim, Mr. Ipek would be acting in breach of the legal costs principle and in breach of his duty as a director of Koza. To that extent, it follows that payments made in breach of the legal expenses principle cannot be treated as the expenditure of funds that properly relates to legal advice and representation for Koza Limited's benefit, nor do I think that they're capable of being payments in the ordinary and proper course of business. It cannot be part of the ordinary and proper course of a company's business to make a payment in breach of an established principle of company law. And then they picked it up finally again at page 1487, paragraph 135. The final factor is the approach that has been adopted by Mr. Ipek in continuing to procure Koza Limited to pay the legal costs of this dispute without making a contribution himself, in circumstances in which courts at every level have made quite clear that this is an inappropriate course for him to adopt. This fact alone is strongly suggestive of the probability that, if injunctive relief is not granted, he will continue to procure Koza Limited to incur expenditure on legal costs without proper regard to the legal principles governing the circumstances in which that expenditure may be appropriate. So that context in our submission, as we would submit, makes the warehousing of the litigation that much more grievous and is a significant element to be taken into account overall in deciding whether or not what has happened is abusive. Finally, one may just step back and contemplate what the consequences of the claimant's arguments are, because the position he would wish to maintain is that since the Turkish directors of Koza Altin should not be recognised in English law as having power to cause Koza Altin to do anything, the outcome is that these proceedings could not be defended by Koza Altin. That's the prize he's after. He's trying to make these proceedings unanswered by running this authority argument. Not only that, if his argument were accepted, it would mean that Koza Altin couldn't even enter a contract or recover a debt in this jurisdiction, because the English court wouldn't recognise its director's ability to cause it to act. With the greatest respect, that is an astonishing outcome. It's essentially a lawless outcome, which he is seeking to produce. And he's seeking to do it in remarkable procedural circumstances, because when the proceedings were issued, apart from getting leave to serve out, he also got leave to serve by alternative means on Mishkon de Rea. Having got permission to serve by alternative means on Mishkon de Rea, he then immediately applies to strike out the acknowledgement of service served by Mishkon de Rea on the basis that they don't have authority because the individuals instructing them aren't to be treated as the directors. Now that, again, of itself doesn't prove that an abusive approach is being taken, but it is, again, in our submission, all of a piece that this whole line of the authority argument is being kept going by Mr. Ipek in order to, in a sense, defer, if not ultimately to frustrate the determination of what can and should have been an incredibly short point of English company law as to whether or not the golden share which he wished upon himself actually works to entrench his position as an irremovable director. There is no reason why we are 6 years on from the issue of the proceedings that raise that point, with no determination, finally, of jurisdiction, other than because Mr. Ipek is using these proceedings to ventilate issues which have nothing to do with this jurisdiction. So we do submit that taken in the round, the process that has been adopted of a piecemeal approach to the jurisdiction followed by delay in issuing the new claim, accompanied by delay in progressing the original claim, accompanied by what very clearly appear to be breaches of duty, taken together do constitute abuse, and we do invite the court to take a different view from the judge below on that. Lord, unless there are any questions, my lady, those are our submissions in response.
No, thank you, Mr.
Thank you.
Thank you very much.
My lords, my lady, can I begin very briefly with the raft of jury points from my learned friend at the end? Mr. Ipek and his family have more than $500 million tied up in the Koza Altin Group. This litigation is about that small fraction which is in England, 60 million. It is wrong, and all the more wrong, when this proceeding is being broadcast around the world, including in Turkey, where Mr. Ipek's brother is currently in jail, to suggest that Mr. Ipek has acted in breach of fiduciary duty, as if a court had made a finding on that. It has not. There has been no trial of that issue. There has been no finding on that issue. There has been no trial of the forgery issue. There has been no finding on it. What there have been is interlocutory decisions, serious issues for trial, high degree of assurance. The serious issue for trial is exactly the same serious issue for trial that arises in the context of the corruption allegations in relation to the trusteeship issue in this case. It is not going to assist this court in deciding the issues before it to be influenced by those sorts of points. On the personal fighting fund point, that is also wrong. Koza Limited's money is used to pursue its business, and primarily its business in mining interests. Mr. Ipek, in good faith, on the basis of legal advice, took the view that it was in the company's interest to fund the 2016 proceedings and the present proceedings. He was wrong to take that view. The English court has said so. It doesn't make it a decision taken in bad faith, still less one in breach of fiduciary duty. Lawless state of affairs, my learned friend says we are trying to procure. We are trying, he says, to stop Koza Altin acting at all. That is fundamentally false. What we are trying to ascertain from the only court which has jurisdiction to determine it is who is entitled to act for Koza Altin in this jurisdiction. And I will come on to this when I show you lordships and your ladyship the pleaded case. But we say this is a case exactly like the Venezuela case, in which there are in effect rival boards for Koza Altin. There is the board comprised of Mr. Ipek and his family, who were validly appointed under Turkish law prior to the campaign of oppression. And then there is my learned friend's clients. And the issue for the English court, exactly like the issue in the Venezuela case, is to choose which of those two rival boards should be recognised as having authority to represent Koza Altin, the foreign corporate, in relation to its assets in this jurisdiction. Finally, his repeated point that we are 6 years on and no further forward. True. And the reason is because they will not submit to this court's jurisdiction to determine the authority issue. The whole debate on the run up to the Supreme Court was about jurisdiction in relation to that issue. The whole debate 2 days before Mr. Justice Trower, 2 days in this court, is about that issue. And it is an utterly arid debate. Because as my Lord Justice Newey put to my learned friend towards the end of his submissions, at some point, the the trustees are going to have to invoke the English court's jurisdiction if they wish to pursue their notices by which they seek to represent the company here. My lords, my lady, with those very brief points, can I go back to what actually matters in this case? And what I propose to do is begin with the core points of principle that I began with yesterday. The ultimate question is the narrow and novel one I identified: how to approach appointments under a foreign judgment. And there are only two possibilities. One is the choice of law analysis, or if one prefers, the applicable law analysis, an analysis that treats the issue as an issue for foreign law. That is my learned friend's case, that is the judge's analysis. And the consequence of the analysis is, you say, it's a foreign corporate. You look to the law of the place where it is incorporated to ascertain its directors. There is a decision of the Turkish court identifying those directors, and that is the end of the matter. That is one potential analysis. The other potential analysis is the recognition analysis for which we contend, which turns on whether the court recognises or not the foreign judgment in line with ordinary principles. Now, my learned friend's argument on all of this was either a pleading point or it was a point about the theory of recognition. And I will come on to both of those points in due course. But I would just invite your lordships and your ladyship to focus for a moment on the substantive difference between those two approaches that I have identified. And the substantive difference is that whereas one of those approaches, the one for which I contend, allows the court to scrutinise, in line with its public policy, the basis for the appointment, the other approach, for which my learned friends contend, does not. And that is in substance what divides us. And if your lordships and your ladyship are looking for a principled way of resolving that difference between us, does public policy in the sense corruption and so on matter? The surest guide to that is the authorities on the in rem judgments, marital status, office holders, through which is a consistent theme that the court approaches the issue as a matter of recognition, not as a matter of applicable law. And the court does that, I would submit, exactly so as to reserve to itself the right to ask two critical questions. First, should the foreign judgment have any effect at all in this jurisdiction? That's the question of the foreign court's competence. Second, does the foreign court's judgment align with English notions of substantial justice? And it is only by taking a recognition approach to the question I identified that the English court is able to put in place those control mechanisms. Because if the approach is instead to treat it as an applicable law issue, the court ends up in the situation that my Lord Justice Newey put to my learned friend, where a company has the misfortune of being incorporated in an endemically corrupt jurisdiction. Its judges, without even trying to apply the law, still less having any power to do so, appoint a board of directors. And the English court's hands are tied. It can do nothing other than say, well, you are the directors as a matter of the law of the place of incorporation, and that is the end of the analysis. In my submission, that cannot be the law. And if it is to be laid down as the law, it should be laid down by a trial judge who has heard the evidence, found the facts, and then applies the principles. My lady, can I deal with the pleading point? My learned friend repeatedly said that there is no dispute, and it is common ground as to who are the directors of Koza Altin. That is only true if the question is posed from the perspective of a Turkish court.
Sorry, posed from the perspective of?
A Turkish court. But the perspective of a Turkish court is utterly irrelevant to our case, because our case is all about the perspective of the English court. And we absolutely dispute that the English court should treat the trustees as directors.
That's about treating, that's not about whether they are the directors.
It makes no difference in my submission whether one puts it as a point about treating them as directors or as to whether they are directors. The point of substance is, for the purposes of this jurisdiction and from the perspective of the English court, who are the directors authorised to represent Koza Altin? The answer on my submission is not the trustees. The answer is Mr. Ipek and the other individuals. Can I just show the court how that is put in the re-amended particulars of claim? It's core bundle 14. If we start with paragraph 9, where we introduce the trustees. Court sees there the second to fifth defendants are the current purported directors of Koza Altin, purportedly appointed in the following circumstances. If the court turns over to paragraph 10, the same point is made about purported appointments. If the court turns ahead to paragraph 105,
Sorry, which paragraph?
105, page 188 in the bundle. Can I just ask the court to read 105 and 106? Now, if, when the trustees come to put in their defence, they deny paragraph 105, they deny that Mr. Ipek and so on were the directors of Koza Altin prior to the Sur judgment, we will reply to that, and we will reply on the basis of Turkish law principles, because their appointments are straightforward private appointments of directors. They don't involve any court orders. But contrast that with a situation in which the trustees were to plead, we are the directors of Koza Altin. We would deny that plea. And the only basis upon which it could be replied to is the Sur judgment. Subject to points about SDIF decision making, I'll come on to those in a moment. I'm just dealing with the Sur judgment part of the case. And that shows why the Sur judgment is at the heart of all of this. Because to make good their right to assert Koza Altin's shareholder rights in this jurisdiction, the trustees have to rely on the Sur judgment unless they can point to some other source of authority. That's the pleading point. The other point I characterise perhaps unfairly as recognition theory, but there was an air in my learned friend's submissions of conflict of law seminar. The court being told how to characterise the issue, what the case is all about. And it was suggested, and this is the proposition that was put, that when the court and this is as my learned friend put it, when the court talks about recognition or enforcement, he says, that means giving legal effect to the substance of the foreign judgment to determine an issue in the case. Now, that seems to us a rather narrow conception of recognition, which sounds close to the idea of a foreign judgment being relied on for res judicata, which is one context in which recognition arises, but not the only one. My learned friend identified no authority for his narrow proposition, and it is inconsistent with the authorities that I showed the court yesterday. So take von Lorang, for example. Marriage was not a substantive issue in that case. The substantive issue in that case was nationality. But in order to make out her case, Miss von Lorang wished to rely on a particular status derived from a foreign judgment. She said, I am unmarried pursuant to this German judgment, and on that basis, the administrator's case as to nationality fails. Take another example, the office holder cases like Bedjarmov. The issue of recognition in Bedjarmov goes entirely to the question whether the trustee in bankruptcy, who appeared before Mr. Justice Snowden, should be recognised for the purpose of being granted rights so as to collect assets and so on in this jurisdiction. The trustee's status was not in any sense a substantive issue in the action that the Russian judgment could be said to be res judicata in relation to. But no matter, because the recognition principle runs wider than my learned friend's narrower formulation. And ultimately, however wide or narrow one puts the point, the whole issue in this case is who is entitled to exercise Koza Altin's rights. And I go back to the point I made at the start of my reply submissions. I invite the court to see two rival boards here. The Ipek board has pleaded at 105 and 106 of the re-amended particulars of claim, and the trustee board. The English court must choose between them, and to make that choice, it either applies Turkish law or it performs a recognition analysis. And the court has my submission that authority, principle, and justice show that it is a recognition issue. Can I turn next briefly to Williams and Humbert? And the court will recall that our core submission in relation to Williams and Humbert is that it is irrelevant because it was concerned with foreign legislation and not with foreign judgments. And to illustrate the importance of that distinction, I took the court to the Foreign Active State case law in order to demonstrate the very different principles that apply to foreign legislative and executive acts on the one hand and judicial acts on the other, and the rationale for that distinction in terms of the rule of law. None of that was gainsaid by my learned friend in his submission. And it follows from that that there is no principled basis advanced for the argument that Williams and Humbert applies by analogy to this case. And there is no principled basis to support the judge's core reasoning in this case. What there is instead is the assertion that Williams and Humbert helps, because that was a case in which the court concluded that there was nothing left to enforce because everything had been done in Spain. But that begs the dispute between us as to whether that is the right approach, what I've termed the choice of law approach or the applicable law approach, or whether the right approach is instead the recognition approach, which we say applies where foreign judgments are in issue. Come next to the Venezuela case. My learned friend said that's totally different from our case because it all depended on who was the president of Venezuela. Now that was part of the debate in that case, but it's vital that your lordships and your ladyship do not misunderstand the context of that case, because there were also in that case various issues about the validity of the appointments to the boards under Venezuelan law that had nothing to do with the president issue. Many of those validity issues, independent of the president issue, had been dealt with by the STJ judgments. And that is why it was so important to ascertain whether those judgments were entitled to recognition in England. Because if they were, that would provide the Majuro board with a way of winning, even if it lost on the one voice points. And equally crucial for the Guaido board to advance their case that the STJ judgments shouldn't be entitled to recognition in England because of the public policy points they raised. And for the court's notes, you see those issues in the Court of Appeals judgment in that case. Lord Justice Mayall's tab 26 of the authorities bundle. Let me just give the court the paragraphs. 14, 15, 17, 24, 25, 28.
Sorry, 14,
I'm so sorry. 14, 15, 17, 24, 25, 28, 31, and 32. Now, we don't have this in the bundle, but the case was originally case managed by Mr. Justice Tier. I appeared at the time for the Bank of England, and the whole purpose of the case management directions that the judge gave, which included the preliminary issue trial that ultimately went to the Supreme Court, was to deal with issues that had the potential to finally resolve the case without having to get into the facts. And that's why the STJ judgments, the validity points under Venezuelan law, they were all parked for the end, because the Guaido board's primary case was that the court would never get into it as a result of one voice and foreign active state. But those issues were very much part of the debate in that case. And once one recognises the true context, my learned friend has no answer to my Lord Justice Newey's point that if everything turns on the lex incorporationis, the court would just have applied Venezuelan law in that case. Because if that is what all turned on, the starting point of the analysis would be the STJ judgments, whether or not they were entitled to recognition. If the recognition analysis is adopted, or if the learned friend's analysis is adopted, there's no recognition inquiry. You just apply Venezuelan law as stated by the STJ. That wasn't the approach, hence the need for the allegations on public policy to be tried out in due course. And that's what I want to say on the core issue of principle. We come next to the SDIF point. And I have this under the heading serious issues to be tried. as to the SDIF legislative and administrative decision making. And there are three issues for the court here. The first is, do we need to impugn the Turkish legislative and administrative acts? We say we do not.
Sorry, because of the banging, I couldn't hear that, I'm afraid.
I'm so sorry, let me try again. Three questions under this topic.
Yeah.
The first, do we need to impugn the Turkish legislative and administrative acts? We say not. And the reason is because all of those legislative and administrative acts only applied to Koza Altin on the basis of the sewer judgment. And all they did was to transfer to the SDIF onto ministers, sometimes back again, and then back to the SDIF, a power that derives from the sewer judgment. And so far as concerns the Ankara criminal court decision, which isn't in evidence, and what the court has rather unsatisfactorily appears to be a press release headed Rumours and News. It's the document you were shown earlier on. But even assuming that's an accurate description of what that criminal court decided, all it is providing for is the continuance of an existing state of affairs, all of which is built upon the sewer judgment. And my submission is that it would be incoherent for the English court to decline to recognise the sewer judgment on public policy grounds, but nonetheless recognise the edifice that is built upon it. So if you take a simple example, assume facts somewhat similar to Oppenheimer and Catamol, except instead of legislation, it's a judgment. It's a judgment which deprives Jews of their nationality. And then there are executive acts which authorise the takings of property against individuals who have lost their nationality. There would be no basis for attacking the executive acts in and of themselves, because the Foreign Act of State doctrine would apply to them. The court would not look into their legality or their validity, it would accept. But in reality, the court would see that they are part and parcel of what offends the court's public policy stemming from the judgment. And we submit that the same approach should apply in the context of the present case. And as far as I'm aware, and this is unsurprising because, as Lord Lloyd Jones points out, this is a notoriously difficult corner of the law, and it is developing. There is no authority to have considered the question how the court approaches the interrelationship between a foreign judicial act, which is not entitled to recognition, and legislative and administrative acts which proceed on the basis of it. And we say again, that is an issue which ought to be dealt with by the trial judge once he or she has tried the facts. So that's the first way we put this. The second question for the court, and this only arises if and insofar as I do need to impugn the Turkish legislation and administrative acts, is what is the scope of the public policy exception to Rules 1 and 2 of the Foreign Act of State doctrine. And in my submission, the scope is not Oppenheimer and Catamol. Oppenheimer and Catamol is a very clear example, perhaps the clearest in our law, of when the public policy exception applies, but it does not exhaust the public policy exception. Rather, the public policy exception is a domestic standard to be articulated by the courts in the ordinary way through the case law. And there is no reason in principle or authority why it is only situations as egregious as Oppenheimer and Catamol that are contrary to the public policy of this court. Indeed, if it is contrary to the public policy of this court to recognise and enforce a corrupt judgment, the court might ask itself, why is the public policy very different when it comes to corrupt legislative and executive acts? And on the point that public policy is a domestic standard, can I ask the court to take up Belhaj in the Supreme Court? This is in volume 2 of the authority bundle. It's behind tab 22.
22.
Tab 22. That was a case in which individuals were alleged to have been rendered from various jurisdictions abroad in furtherance of a conspiracy among various governments, including our own. One of the issues was whether the Foreign Act of State doctrine applied so as to prevent the English court from investigating the relevant acts of the foreign governments. To which it was riposted, well, if it does apply, there's a public policy exception for conduct like this. And what Lord Neuberger is considering at paragraph 154 to 156 is the public policy exception. And can I ask the court to read 153 down to 156?
Yeah.
That's the second point, the true scope of the public policy exception. And the court has my submission, it runs broader than Oppenheimer. And then the third issue on this topic is whether our factual case, as pleaded, is sufficient for us to invoke the public policy exception. In the context of the allegations in the re-amended particulars of claim, my submission is plainly yes, they are sufficient. Come next to the Turkish Constitutional Court. My learned friend said, provided there is bona fide scrutiny by some appellate court, that is enough to cure corruption in the lower court. Now, if that is advanced as a point of law, it is wrong. It is not borne out by Maximov or Rogerstrak, which are the only authorities cited on this point in my learned friend's written argument, and the court has my submissions as to why neither of those cases lays down a proposition of law, and each involved facts very different from this case, because they were cases involving conventional appellate courts and not constitutional courts such as the Turkish Constitutional Court. The court might take another example of this. Take a case where the appellate court, acting perfectly properly in good faith in line with natural justice, has no jurisdiction to consider allegations of bias in the lower court if they were put to that court. Or take a similar restriction that fraud in relation to the lower court's judgment can only be charged on the basis of fresh evidence that couldn't, with due diligence, have been put below the lower court. The second of those principles is fairly close to the English court's practice when it comes to reviewing other judgments said to have been procured by fraud.
I'm not sure it is anymore. Anyway, that's very high.
But at least it was. And it still may be. But your lordships and your ladyship happily don't need to resolve that on this appeal. But what is clear is that the approach in the cases of foreign judgments is fundamentally different. This court will investigate an allegation of bias if it is a proper allegation, irrespective of whether it was put to the lower court and rejected. This court will investigate an allegation of fraud in relation to a foreign judgment, even if it is based on exactly the same material that was put to the foreign court. That is the Abeloff and Oppenheimer principle from AK Investments, also known as Altino. And that's a point the court will need to resolve either, where Lord Collins found that it was arguable that that exception applies in the context of judgments in rem. So, advanced as a proposition of law, the submission that it is sufficient that there have been some review by an appellate court is unsustainable. Ultimately, as with much in this case, it all turns on the facts. And our short submission here is that there are serious issues to be tried as to whether the Sur judgment and the corruption which it involved was cured by the application to the Constitutional Court. And just to remind the court of two aspects of my submission yesterday that were not challenged by my learned friend, I identified for the court 4 aspects of my case that are for trial. First, that the rule of law generally in Turkey has broken down. Secondly, that there is a campaign by the Turkish authorities against Mr. Ipek as an alleged Gulenist. Third, that the Sur judgment is corrupt. Fourth, that its corruption was not cured by the horizontal appeal to Judge Sahin Bey. And it is not in dispute that on each of those topics there are serious issues to be tried. Now, it doesn't assist my learned friend to say, well, we only accept that they raise serious issues to be tried for pragmatic reasons. That may well be right. The point is they are matters for trial. And so the question for the court is, on the premise that they are matters for trial, how does the Constitutional Court judgment fit into the picture? The second contextual point that I made to the court yesterday was to identify 8 propositions derived from the Jowl report. I won't repeat those, they're on the transcript and the court has the note we handed up. Again, none of that was disputed in the sense that there is no dispute that on each of those 8 points there are serious issues to be tried. And the question for the court is, given all of that, do we have a triable case to impugn the Turkish Constitutional Court decision? And we say again, the answer is plainly yes. And it was telling that in my learned friend's submissions on this, he didn't put the Turkish Constitutional Court judgment in the context as we allege it to be. What he did was to take it in isolation and say, well, it's a very long and detailed judgment. It reads a bit like an ECHR judgment. And on that basis, I have no serious case to challenge it. But that is not the real world in which this issue will arise at trial, because the issue will arise at trial as part of a series of allegations in relation to failings in the Turkish state at the relevant period, all of which go to the heart of the authority issue. My learned friend enthusiastically took a pleading point on this part of the case and said, we haven't pleaded out our case in relation to the Turkish Constitutional Court. That is true. But we will amend in order to plead the case that I have articulated to the court in the course of my submissions and in our written arguments. And if the court is satisfied that those points raise serious issues to be tried, the fact that they have not been pleaded is neither here nor there. And that's particularly so where the suggestion that the Turkish Constitutional Court decision could of itself provide a basis for summary dismissal of our claim is a point taken for the first time on this appeal. I don't suggest there was no debate below about the Turkish Constitutional Court. There was. But it was not put as a freestanding basis upon which summarily to dismiss our whole claim. And had it been put that way, it would have been dealt with differently in the evidence. The final point on this topic is that my learned friend said, well, the Turkish Constitutional Court has been blessed on several occasions by the European Court of Human Rights. So it has. That's not the issue for the court. This court is not concerned in general with the role of the Turkish Constitutional Court. It is concerned with its role in Mr. Ipek's case. We come next to the ECHR decision. 3 short points on that. The first is it is not res judicata. It does not preclude my client from running any part of its factual or legal case. It cannot be res judicata because quite apart from the different issues which the 2 proceedings raise, it involves different parties. My learned friend's only answer to that point was to suggest, so far as I'm aware, for the first time in the course of these proceedings, that it would be an abuse of this court's process for Mr. Ipek to advance arguments against the trustee that he hasn't advanced before the European Court of Human Rights. Now that's not only a brand new point, it's also a point that is utterly ill-suited for summary determination, because in order to determine it, the court would need first of all to have the evidence as to what exactly Mr. Ipek put before the European Court. The court doesn't have that. The court would need to be addressed at much greater length than has been possible on how the abuse of process jurisdiction operates, insofar as it operates at all, in relation to different parties from the original proceeding. And none of that has happened because it's a brand new point. So that's res judicata. The second point is admissibility. It is a well-established rule in this jurisdiction that findings of other courts and tribunals are not admissible as evidence of the truth of those findings. That is the rule in Hollington and Hewthorne, and that is the rule that will apply in these proceedings. So it will not be possible at trial in this case for Mr. Crowe to point to a factual finding in the European Court's decision, any more than in the Turkish Court's decision, and say that that is true. It will be for the English court to investigate the truth or otherwise on the basis of admissible evidence before it. And my learned friend refers to Ellen Kane and the duty under Section 2 of the Human Rights Act to take account of European Court case law. We don't dispute any of that. It's just utterly irrelevant. What Ellen Kane was about was a case in which the Court of Human Rights had said that a particular act, as to the facts of which there was no dispute, fell within the margin of appreciation of the relevant state. The question was, should the domestic court go further and say, well, although it was within the margin of appreciation, nonetheless it infringed the right? The Supreme Court held that that's not what should happen, because that was to misunderstood the margin of appreciation as a concept applied in the European Court's case law. That has nothing to do with the present case, in which Mr. Ipek is not asking the English court to grant rights of a different scope from those considered by the European Court. What he's asking the court to do is to resolve his case on the basis of the allegations he has pleaded, and his pleaded allegations do not correspond to the factual assumptions made by the European Court. And the third and final point we make on the ECHR decision is that it's not final. And my learned friend said to you, well, that's a hopeless application for Mr. Ipek to make. With respect, again, that is not a matter upon
What
which...
about Article 28, 1 and 2?
Let me address that, my lady. The application is put on two distinct bases. The first is the submission that the committee acted in excess of its jurisdiction, because the case was one which ought not to have been referred to a committee, but should have been referred to a chamber applying the relevant guidance. So the case that is put...
What guidance?
So as I understand it, and I'm not involved in the applications of the European Court, the argument being made is that the judge rapporteur who makes the decision as to whether the case goes to a committee or goes to a chamber is bound by guidance which explains how that decision is to be taken.
Right.
And in short, the guidance is straightforward cases to the committee, more difficult cases to the chamber. And the judge rapporteur did not follow that guidance in the present case. And that is said to have deprived the committee of jurisdiction. That's one basis upon which it is put. And then the second basis upon which it is put is to say that the decision contains grave and manifest errors that should be corrected. And those grave and manifest errors are in large part to align what Mr. Ipek says are the false assumptions that the Court of Justice has made, that the European Court has made, with what he says is the true position. And then the final part of his argument is to say, having resolved those problems, the court has a power to restore the application to its list, and having been restored to its list, the decision arises afresh, committee or chamber, and this is a clear case for the chamber. That's how the application is put. And in my submission, it's not a relevant, possible, or appropriate area of inquiry for this court to express any view on whether it's a good, bad, or indifferent application. It's not relevant because even if the decision is final, it is not binding and not admissible. I've addressed the court on that. It's not possible for the court to form a view about Mr. Ipek's application because, and a simple point, the court doesn't have the application materials before it. court hasn't received any proper argument as to the issues to which the application gives rise. And it's not appropriate because, with all due respect, it is for the European Court to say whether Mr. Ipek's application is a good one. It is not for this court to do so. I come next to Gateway. And by the time we've got to this stage of the argument, the court will have concluded that our case raises serious issues for trial, and it is of course agreed that the English court is the only court that could determine it. And the Gateway, in the end, turns on a very short point about attribution. If we win on the authority issue, acts done here by the trustees will be their own acts. They will not be Koza Altin's acts. So say, for example, the trustees instruct an agent in the jurisdiction, say a solicitor at Mishcon de Rea, to hand deliver a new Section 303 notice to Koza Ltd. And that instruction is given in the name of Koza Altin. If we are right on the authority issue, the delivery of that notice to Koza Ltd, an act in the jurisdiction, is an act attributable to the trustees. It is not an act attributable to Koza Ltd, to Koza Altin. And once that basic point on attribution is recognised, as the judge did rightly recognise it, the Gateway quite obviously applies. We come finally to abuse of process. 3 preliminary points about this argument. The first is its ambition. By this stage of the argument, what the trustees are trying to do is to shut down a triable claim, raising issues on corruption, public policy, foreign act of state and so on, which passes through the gateways and in respect of which England is the appropriate forum. In my submission, it would require the clearest possible facts to support the conclusion of abuse in such a context. The second preliminary point is that the argument is an entirely arid one, because what the trustees are seeking to attack is the procedural vehicle for raising the authority issue, not the substance. And as my Lord Justice Newey put to my learned friend, one way or another, the substance is going to come back before an English judge at some point, if this case raises serious issues to be tried. And the third preliminary point is that there was no dispute about the applicable principles on abuse of process below, and nor is there any dispute about them in this court. It is common ground that the principles are set out in this court's judgment in a prior installation of the Koza litigation from last year. Can we turn that up? It's tab 38 in the third authorities bundle. We don't need to go back to the judgment, but Mr. Justice Trower specifically directed himself by reference to these principles. The relevant passages begin at paragraph 30 in Lord Justice Hall's judgment. I anticipate that all of this will be very familiar to the court, but I just want to remind the court of its own function when hearing an appeal against abuse. This is the point made at subparagraph, if you could turn to page 1417 in the electronic numbering.
Yeah.
We emphasise in particular
Subparagraph 6.
subparagraph 6 and also the citation to Aldi stores. Can I ask the court to just refamiliarise itself with what is no doubt a very familiar passage.
Well, it's the point about the Lord Justice Thomas made in all these stores, isn't it?
Exactly. And with respect to my learned friend, his oral argument on this completely ignored what ought to have been the focus of the exercise. What he did was to assume that he was entitled to re-argue this afresh and run all the points he ran before the lower court. He's not entitled to do
The only issue for us is whether Mr. Justice Trower erred in what was on any view. If it wasn't the exercise discretion, it was nonetheless a multifactorial assessment by the court.
Indeed.
There.
And with that in mind, can I focus?
He did, but to be fair, Mr. Crowe did say that the judge had failed to give sufficient weight to a series of matters that he-
You see,
Weight
weight is not a permissible point for him to take. The points he can take are
Yes, I
errors
follow
of
that.
principle. Well, there can't be any of those because
Well,
the
no weight
principles
at
are
all
all
you
agreed.
could take.
Well, no
Or
weight at
ignoring.
all
Fail to
must
have
be.
regard to
Yeah,
a
fail to have
material
regard.
consideration.
So-
And
so-
I don't think there were any considerations that he said were left out of account altogether. He disagreed with the weight or the emphasis placed on it by the judge.
Yeah.
Indeed. The only permissible complaint here could be failure to take into account considerations, and as a lady puts it, there isn't any of that, or, remarkably, a perversity challenge. And there was some suggestion of that in the skeleton, but no doubt my friend couldn't bring himself to say it out loud, and so it wasn't. And so the short answer to all of this is that, interesting as my learned friend's presentation on abuse was, completely irrelevant. He's not allowed to run that case in this court. And that's the short answer to this point. Now, if, contrary to that, this court does somehow find an appellable error in the relevant paragraphs of the judgment and does come to consider for itself whether the approach my client took was an abusive process, the answer is it plainly was not. And it plainly was not because it's doubtful, first of all, whether we could have maintained the shadow application for permission to serve out. Now, it's important here to appreciate the distinction between the hearing in front of Mr. Justice Snowden and the hearing in front of Mrs. Justice Asplin. Before Mr. Justice Snowden, we appeared without notice, seeking urgent interim injunctive relief under duties of full and frank disclosure to the court in the usual way. And it would have done my clients no good to make their arguments on injunction and the court to say, I'm very sorry, we don't have jurisdiction under the Brussels regulation. And so in that context, it was obviously sensible to advance as a fallback an alternative application for permission to serve out. Lest the court said, well, I'm with you on the substance, I definitely should grant you this injunction, you've got serious issues to be tried, but I'm worried about jurisdiction because you've only identified the regulation and I don't think it applies. And so in that context, it made sense to run the alternative application. And the court will see what Mr. Justice Snowden did with the alternative application, as I would suggest most judges would. He concluded he didn't need to deal with it because he had found for us on the Brussels basis that was our primary argument. We then move on to the on-notice stage of the case, which comes before Mrs. Justice Asplin in December that year. And by that stage, my learned friends have on foot an application to challenge the court's jurisdiction, an application under CPR Part 11. One of the court's powers under CPR Part 11 is the power to grant a declaration that the court has no jurisdiction. So if they really wanted preemptively to resolve the permission question, they could. They could have asked Mrs. Justice Asplin to declare But not only was this not a case within the Brussels regulation, which was their primary argument, but also that this case was not appropriate for service outside the jurisdiction. Now, whether or not she would have acceded to that, taken the view that it was not sensible case management, one could speculate. But it was open to them to raise the issue before the court in that way. At the very least, it was open to them, to my learned friend's predecessor, to follow through the threats that they had made in correspondence and to ask Mrs. Justice Aspelin to grapple with the issue. For example, they could have asked her at the oral hearing to give directions for the making of a permission to serve out application. Or they could have asked her to tax my client's leading counsel at the time as to why are you not bringing this permission to serve out application? But they didn't do that. They marched all the way up the hill in the run up to the hearing, and then they didn't push the point. And that is a relevant consideration, and that is a consideration that the judge took into account, and we'd invite this court to take into account too. And as to the focus on what we could have done, the very most we could have done was to make a contingent application and press the court to deal with it, even if it was with us, on our primary position that service out as of right was available. But we could never have been granted permission to serve out, because once the lower court concluded, as Mr. Justice Snowden and Mrs. Justice Aspin had, that service out was available as of right, there is no power in the court to permit service out. The way CPR 6.33 and 6.
That's why it's not a true alternative, because the reality is that once you decided under the exclusive jurisdiction, that's the beginning and the end of it.
Indeed.
Which is why I put to Mr. Crowe, certainly in my experience, most judges would have said, well, what's the point?
Yeah.
There isn't, I can't make an order in your favour. All we'd be doing is debating whether something which is academic might or might not turn out in your favour at the end of the day. Surely the best course is to leave that over just in case you ever need to.
Indeed. And that was the course we took.
Yeah.
And just to deal with my learned friend's riding two horses point, it is true that we were also advancing submission as a basis for the court's jurisdiction. But of course, submission is a head of jurisdiction under the Brussels regime.
Yeah.
So it was entirely consistent with our stance that the Brussels regulation conferred jurisdiction for us to say, well, we win either on Article 24 or we win on submission. What would have been entirely inconsistent and unusual and pointless was for us to run a shadow permission to serve out application alongside.
Yeah.
So that's the could part of the analysis, and we say really it's very doubtful whether we could have done that. But even if we could, why should we? Why should we have gone to the cost, which would have been significant, and the additional court time, which would have been significant, to pursue a shadow application, which on our case the court could never grant? And the course we took appeared reasonably likely at the time to minimise costs. We had won in front of Mr. Justice Snowden on this point. We then won on it again in front of Mrs. Justice Aspelin. We won on it again in this court. It was only when Lord Sales got hold of the issue that everyone realised that we got it wrong. Now, in hindsight, of course, one can say that has put the parties to additional time and cost. It's actually very difficult to ascertain what the additional cost is, because the issue is really just when the cost is incurred. And it's also quite difficult to ascertain what additional time has been added onto all of this. But the point is, that's all done with hindsight. What the court must do is put yourself in my client's position at the time. Is the only thing they should have done on pain of abuse of process be to move this shadow application? And we say plainly not. And then as for delay, warehousing, and so on, these are all considerations taken into account by the judge. And in this case, they don't carry any weight. And one of the reasons in particular why they don't carry any weight is that the main contributor to delay in litigation is not the conduct of my clients, it's the conduct of the trustees and the predecessors in refusing to submit to the English court's jurisdiction on a matter which will come here, come what may, one way or another. And when the court is being required to perform a broad merits-based analysis, which takes account of all facts, we do invite the court to bear in mind the utterly arid nature of the trustee's stance on jurisdiction. Because one way or another, unless they give up, the authority issue is going to have to be resolved by an English judge. Unless I can assist the court further, those are my submissions in regard.
No, thank you very much indeed. Well, thank you all very much for your extremely helpful submissions, and thank you to those behind you, and also I know to Mr. Trotter, I'm sure he has done a lot of work, although he's not actually in the jurisdiction. We're obviously going to reserve judgment. No promises as to whether you'll get a judgment this side of the long vacation. The chances are probably not, but we'll certainly get you a judgment as soon as we can. When you get the draft judgment, it's for the correction of obvious typographical errors and the like. It is not for inviting the court to reopen argument on issues. And if you could possibly, in due course, agree a form of order, that would be extremely good. If you can't, we'll deal with any issues that are outstanding on paper. The only other thing I ought to say, given the fact there have been a number of breaches of the embargo in the recent past, is how important the embargo on the draft judgment is, that access to any draft is really to be limited to those who have responsibility for the conduct of the case, particularly for the issue as to what corrections are to be provided. It's not for widespread dissemination. If it's necessary for whatever reason to disseminate to anybody else within an organisation or the solicitors, then permission needs to be sought, and any breach of the embargo will potentially be a contempt of court. But thank you all once again.
Court rise.